Welcome to the first video of the sixth unit in this course on fundamental rights in the Constitution. In the last unit, we looked at Articles 20 and 22 of the Constitution. In this video, we will be looking at Article 21 of the Constitution, which is perhaps the most important fundamental right in our Constitution. Let us begin by reading its text. No person shall be deprived of his life or personal liberty, except according to the procedure established by law. In a recent judgment, the Supreme Court described these lines that we just read as the Ark of the Covenant, signifying the importance attributed to Article 21. Article 21 was drafted in this form after a serious debate in the Constituent Assembly. The primary reason for the debate was the American experience with what was known as the Due Process Clause. The 5th and 14th Amendments to the US Constitution contain this Due Process Clause. Let us first read the 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Recall Clause 39 of the Magna Carta that we had discussed previously in this course. The Fifth Amendment to the US Constitution is inspired by the Magna Carta, which had become part of the English Common Law by 1789, which is when the Bill of Rights was added to the US Constitution. The Due Process Clause, much like the Magna Carta, provides several protections, including protection against arbitrary arrest or seizure of property by the state. The 14th Amendment to the US Constitution extends the Due Process Clause to the states. This amendment was added to the US Constitution following the Civil War in the 1860s. It was passed by the Congress in 1866 and ratified by the states in 1868. Let us now understand the American experience with the Due Process Clause. The Due Process Clause places restrictions on state action. It acts as a safeguard against the arbitrary denial of life, liberty, or property by the government without the sanction of law. However, what does the term due process mean? The exact meaning of the term is not clear from the text of the US Constitution. This gives considerable leeway to judges to interpret these terms. This also leaves them open to the charge that they are altering the contents of these rights. Several decisions of the US Supreme Court have been critiqued on the ground that unelected judges have supplanted the wisdom of an elected legislature, all in the guise of interpreting the Due Process Clause. Let us consider an infamous decision, Lochner versus New York. A law had fixed the maximum hours that an employee could work in a bakery at 10. A baker in New York was charged with violating this law and he challenged its validity. The majority of the Supreme Court of the United States held that the New York legislature had interfered with the liberty of individuals to contract under the 14th Amendment in an unfair manner. The US Supreme Court held that the state's claim that the law is a health law was not correct. On this pretext, the liberty of free persons to contract cannot be restricted. Oliver Wendell Holmes, who was one of the 4 judges, dissented. He noted that the court had essentially overturned an economic decision that the majority of the country had a right to embody in legislation. Opinion was divided in India's Constituent Assembly as it considered the right to life. On one side were those who argue that courts must have the power to evaluate whether a law is just and fair. They argued that merely requiring procedure established by law should not mean that if there is some state-made law, life or liberty can be deprived. The other side, which included Alladi Krishnaswamy Iyer, was of the firm view that the legislature should be trusted rather than the courts. Referencing Lochner, he said that granting judges the power to determine what is just and fair would breed inconsistency in the law. Ambedkar, the chairman of the assembly, expressed no view on the subject and left it to the House to decide on the basis of a vote.
An amendment which was moved to introduce due process into the text of Article 21 was rejected by the House. Ultimately, the clause in its current form was adopted.
Article 21 in its current form is inspired by Article 31 of the Japanese Constitution. This was a clause inspired by the American experience and drafted with the intention of preventing judges from substantively reviewing the policy decisions of legislatures.
So, what does the clause procedure established by law mean? In 1950, after the new constitution came into force, this issue was at the heart of one of the first cases before the new Supreme Court.
Since December 1947, A.K. Gopalan, a prominent communist leader, had been detained under various orders passed by the state of Madras.
In March 1950, on being served with one such order, he challenged the Preventive Detention Act of 1947 as being in violation of the Constitution. Two important submissions made by A.K. Gopalan before the Supreme Court were rejected.
First, it was argued that law in Article 21 refers to certain fundamental principles of a just legal system. These fundamental principles included the right not to be deprived of liberty without a trial in which guilt for objectionable conduct is determined. Second, it was claimed that law in Article 21 cannot be read to mean just any state-made law. Gopalan also argued before the Supreme Court that Articles 14, 19, 21 and other rights in Part 3 cannot be read separately.
This consequence of this argument would be that preventive detention, for instance, should not be tested with respect to Articles 21 or 22 alone, but also against Article 19.
Arrest of a person affects not only his liberty but also his right to movement. Where the rights overlap, it was argued that any infraction by the state must be tested against all rights and not just any one right.
The Supreme Court rejected these contentions.
First, the court held that the expression law in Article 21 has no import outside its natural meaning of enacted law. So, if there was a procedure that was established by law, the petitioner could have no cause for complaint. Second, the court held that the fundamental rights could not be applied simultaneously. They should be treated as separate articles addressing different situations.
Thus, the court reasoned that as Gopalan was complaining against detention, the court was required to evaluate the validity of state action only against the limits placed by Articles 21 and 22 and not Article 19. On these grounds, a majority of the court dismissed the application filed by Gopalan. The majority found that law in this case largely complied with the requirements of Article 22, except for Section 14 of the law, which was declared unconstitutional. That, however, was a procedural provision and did not result in the relief of release from detention for the petitioner. The case was heard by a bunch of 5 judges, of whom Justice Fazl Ali and Justice Mahajan dissented. Justice Fazl Ali authored a powerful dissent, accepting the arguments advanced by Gopalan on Article 21. He held that it would be an error to treat various articles in Part 3 as mutually exclusive.
He also held that the term law used in Article 21 could not mean enacted law alone. It must meet the requirement of being a fair procedure at the minimum. He noted, still the balance between the maintenance of individual rights and public good can be struck only if the person who is deprived of his liberty is allowed a fair chance to establish his innocence. And I do not see how the establishment of an appropriate machinery giving him a chance can be an impediment to good and just government.
Gopalan represented an unduly narrow reading of Article 21 and more generally of Part 3 of the Constitution.
This narrow reading of Article 21 continued through the 60s. For instance, the Supreme Court in 1960 found it unthinkable that a right to livelihood could be a part of the right to life.
Kharak Singh is another prominent example of a restricted reading of Article 21. Here, the petitioner, who was a so-called history sheeter, was subjected to surveillance by the state. A history sheeter is a person who has a criminal record of some kind. In this case, the petitioner had been charged with an offence. He had, however, been released as there was no evidence against him.
The court held that there is no right to privacy implied or explicit in the Constitution. As such, keeping a watch on a history sheeter was not an impermissible measure. The court, however, held that surveillance in the form of domiciliary visits at night violated ordered liberty. In Kharak Singh, as in Gopalan, there was a strong dissent. Justice Subbarao, who dissented from the majority opinion, observed that the right to privacy is an essential ingredient of Article 21. He also rejected the theory of the mutual exclusivity of fundamental rights that had been put forward in Gopalan.